Hello viewers, in this lesson we will learn about several banking legislations. Look at the objectives of this lesson. The Scheme of Banking Regulation Act 1949, important provisions under the Banking Regulation Act 1949, Reserve Bank of India Act 1934, allied legislations relating to banking in India. This lesson outlines the various banking legislations which have direct and indirect bearing in running the banking business in India. We will now look at the Scheme of Banking Regulation Act 1949. The Banking Regulation Act 1949 was previously called the Banking Companies Act 1949. The name was changed as the Banking Regulation Act 1949 by the Banking Laws Application to Cooperative Societies Act 1965, Act 23 of 1965 with effect from 1st March 1966. Originally, the Banking Companies Act 1949 was passed with the objective to consolidate and amend the law relating to banking companies. Subsequently, the word companies was omitted by Act 23 of 1965 with effect from 1st March 1966. Legislative history depicts that this particular legislation was enacted in the year 1949 to curb abuse of powers by certain persons who were at the helm of some banks and also to safeguard the interest of depositors and to protect the economic interest of the country. This enactment was amended in the year 2007 by the Banking Regulation Amendment Act 2007 and further amended in the year 2012 by the Banking Laws Amendment Act 2012. The Banking Regulation Act 1949 is divided into 5 parts and 56 sections. Part 1 of the Act pertains to preliminaries like short title, application of the Act, etc., and contains sections 1 to 5A. Part 2 consists of sections 6 to 36A and contains various provisions like the definition of bank, banker, banking or banking company, and various issues related to running of the banking business and the power of the Reserve Bank to give directions and also to control the banking affairs. Part 2A consists of sections 36A to 36AC on the powers of Reserve Bank of India to remove managerial persons and appoint additional directors, etc. Part 2B relates to prohibition of certain activities in relation to banking companies under section 36 AD. Part 2C contains sections 36 AE to 36 AJ relating to the acquisition of the undertakings of banking companies. Part 3 relates to suspension of banking business and winding up of banking companies under sections 36B to 45. Part 3A relates to special provisions for speedy disposal of winding up proceedings under sections 45A to 45X. Part 3B contains provisions relating to certain specific operations of banking companies under sections 45Y to 45ZF. Part 4 pertains to miscellaneous provisions like penalties, etc., under sections 46 to 55A. Part 5 relates to application of the Act to cooperative banks under section 56. This Act has 5 schedules containing various formats, and details have to be furnished by the banking institutions in these formats. The second schedule was repealed by the Act 36 of 1957. Viewers, we will now look at the important provisions under the Banking Regulation Act 1949. The application of the Act. Under subsection 2 section 1 of the Act extends to the whole of India. By Act 62 of 1956, the words except the state of Jammu and Kashmir were omitted, and since then the Act is applicable to the entire India. We will now look at the major amendments of the Act. The Banking Regulation Amendment Act 2007. By this Amendment Act, Section 24 of the Banking Regulation Act 1949 was amended, providing for maintenance of percentage of assets, and Section 35 of the Act pertaining to the powers of the central government on the recommendations of the Reserve Bank of India to exempt by notification certain companies, and a laying of exemption notification in case of exemptions granted to institutions, banks, branches located in special economic zones, in short called as SEZs. The Banking Laws Amendment Act 2012. This Amendment Act was passed by the Parliament with a view to develop further the banking sector in India and give more regulatory powers to the Reserve Bank of India. Further, this amendment enables the nationalized banks to raise share capital by issue of preference shares. This Amendment Act further facilitated for opening of new banks through licensing policy and also providing for more banking facilities, and in turn facilitating additional employment opportunities in banking sector. We will look at the salient features of this Amendment Act. Banking companies are permitted to raise share capital by way of issuing preference shares in accordance with the regulatory guidelines issued by the Reserve Bank of India. RBI, that is the Reserve Bank of India, is provided with more powers to collect information and inspect the associate institutions of banking companies. The cap on restrictions on voting rights is increased. Prior approval of Reserve Bank of India is needed for acquisition of 5% or more shares or voting rights in a banking company by any person. The Reserve Bank of India is empowered to impose such conditions as it deems fit in the circumstances. The RBI is empowered to supersede the board of directors of a banking company and appoint administrator till alternate arrangements are made. Primary cooperative societies are permitted to carry on the business of banking after obtaining a license from RBI. Special audit of cooperative banks is provided by enlarging the scope of Section 30 of the Banking Regulation Act 1949. The Reserve Bank of India is empowered to issue new bank licenses to corporate houses. As for example, during the year 2014, the RBI has given license to two corporate entities, Mumbai-based IDFC Bank Limited and Kolkata-based Bandhan Bank Limited. The monetary penalties which can be imposed by the RBI are increased. A fund by name Depositor Education and Awareness Fund is created, and the RBI is empowered to transfer the money lying in the bank account, which is not operated by the account holders, or any amount remaining unclaimed for more than 10 years, to the Depositor Education and Awareness Fund. Provisions have been made out to regulate and administer the fund. These amendments are highly beneficial to the banking sector in general and to the shareholders of the banking companies in particular to visualize more profits and benefits. The provisions of the Banking Regulation Act 1949 apply to different kinds of banks. The provisions of this Act, except Section 56, applies to all banking companies which are not nationalized. Under Section 51 of the Act and also under Sections 3, 5 and 20 of the Banking Companies Acquisition and Transfer of Undertakings Act 1980, several provisions of the Banking Regulation Act 1949 are made applicable to nationalized banks. All the provisions of the Banking Regulation Act are not applicable to the nationalized banks. The Banking Regulation Act applies to all cooperative banks, the paid up share capital and reserves of which are of the value of rupees 1 lakh or more. That means this Act does not apply to such cooperative banks, the paid up share capital and reserves of which are less than rupees 1 lakh. However, the provisions of the Act as applicable to the cooperative banks must be read as modified by Section 56 of the Banking Regulation Act, which contains exclusively provisions relating to cooperative societies. We will now look at the scheme of the Act. Preliminary. Sections 1 to 5 under Part 1 of the Banking Regulation Act contain the provisions on the preliminaries like the short title, extent, interpretation and related issues. The provisions relating to business of banking companies. Section 6 to 36A under Part 2 of the Act contain the various provisions under the Act relating to form of business in which banking companies may engage, the definition of the terms bank, banker, banking or banking company, prohibition of trading, board of directors, chairman, the RBI powers thereon, regulation of capital, dividend, audit, inspection, powers and functions of Reserve Bank of India, etc. The provisions on control over management. Sections 36AA to 36AC under Part 2A of the Act provide for the control over the management of banks by the Reserve Bank of India. Prohibition of certain activities in relation to banking companies. Sections 36AD under Part 2B of the Act contain the provisions on awarding punishment to the offenders for certain activities in relation to banking companies like obstructing any person from lawfully entering or leaving any office or place of business of a banking company or from carrying on any business there and such other related and complementary issues. Acquisition of the undertakings of banking companies in certain cases. Sections 36AE to AJ under Part 2C of the Act contain the provisions for the acquisition of the banking companies by central government and the related issues like the power of the central government to make schemes, compensation payable to the shareholders, constitution of tribunal for the purpose of this part, and dispute resolution and other issues related thereon. Suspension of business and winding up of banking companies. Sections 36B to 45 under Part 3 of the Act contain the provisions on the suspension of business and winding up of banking companies and related issues like appointment of liquidator by the Reserve Bank of India, the preferential payments to depositors, the powers of High Court and other related issues thereon. Special provisions for speedy disposal of winding up proceedings. Sections 45A to 4510 under Part 3A of the Act contain the provisions on speedy disposal of winding up proceedings, the power of High Court, appeals, special period of limitation and other connected issues. Provisions relating to certain operations of banking companies. Sections 45Y to 45ZF under Part 3B of the Act provide for the powers to the central government to make rules for the preservation of records, notice of claims of other persons regarding articles not receivable, release of content of safety lockers and other related issues thereon. Miscellaneous provisions. Sections 46 to 55A and Part 4 contain the provisions relating to penalties, offences, fines, special provisions for private banking companies, power to remove difficulties and such connected issues. Application of the Act to cooperative banks. Section 56 under Part 5 contains the provisions relating to the application of the provisions of the Banking Regulation Act to the banks run under cooperative societies with appropriate modifications. We will now look at the schedules to this Act. This Act contains 5 schedules, and the second schedule was repealed by the Act 36 of 1957. The first schedule contains the details of amendments as provided under Section 55 of the Act. The third schedule contains the form of balance sheet under Form A in accordance with Section 29 of the Act. The fourth schedule contains the list of debtors as provided under Section 45D2 of the Act. The fifth schedule contains the principles of compensation in accordance with Section 36AG of the Act. Further, depending upon the necessity and circumstances of the issues, the relevant banking rules must be referred. The statement of objects and reasons of the Banking Regulation Act 1949 contains a detailed objects of the Act and also the features of the Banking Regulation Bill. The further details of the Act are stated in various foregoing lessons of this subject. We will now look at the Reserve Bank of India Act 1934. First, let us have a bird's eye view. The Reserve Bank of India is the Central Bank of India. It was established on 1st April 1935 under the Reserve Bank of India Act 1934. The historical development of the bank and the legislation can be found in Lesson 1. There are several amending acts, ordinances, regulations and adaptation orders relating to the functioning and powers of the Reserve Bank of India, and the viewers can read them from the bare act of any publisher or download from the website of Reserve Bank of India or from the internet under the caption List of Amending Acts, Ordinances, Regulations and Adaptation Orders relating to the functioning and powers of the Reserve Bank of India. Preamble of the Act. The preamble says that this enactment is provided to constitute a Reserve Bank of India to regulate the issue of banknotes and the keeping of reserves with a view to securing monetary stability in India and generally to operate the currency and credit system of the country to its advantage. This Act contains 61 sections. Originally, the word British India was used for India, as the Act was enacted in the year 1934. But after independence, with effect from 23/3/1948, the word British India was replaced with the word India. We will now look at the scheme of the Act. Originally, this Act was divided into 5 chapters and 4 schedules. Some sections and schedules 3, 4 and 5 were repealed. Certain major amendments were brought during the year 2010 by inserting Chapter 3E pertaining to joint mechanism of functioning of the bank by the RBI and the central government, the SEBI, Insurance Regulatory and Development Authority, and the Pension Fund Regulatory and Development Authority. We will now look at the features of the Act. Sections 1 and 2 relate to short title, commencement, extent and several important definitions like scheduled bank, cooperative bank, foreign currency, etc. This Act extends to the whole of India. Sections 3 to 19 relate to the incorporation, capital management and business transactions of the RBI. It also contains the provisions on the business which the RBI may not transact. Sections 20 to 45 deal with the functioning of the RBI, its obligation to transact government business and supplying different forms of currency, denomination of notes, forms of bank notes, issuing of the notes and transactions in foreign exchange, appointment of agents, etc. Sections 45A to 45G deal with the issues relating to the collection and furnishing of credit information. Sections 45H to 45QB pertain to the provisions relating to non-banking institutions receiving deposits and various financial institutions. Sections 45R to 45T deal with the prohibitions regarding acceptance of deposits by unincorporated bodies as defined by the Act. Sections 45U to 45X relate to the regulation of transactions in derivatives, money market instruments or securities, etc. Section 45Y relates to joint mechanism in functioning of the bank by the RBI and the central government, the SEBI, the Insurance Regulatory and Development Authority and the Pension Fund Regulatory and Development Authority. Sections 46 to 58A deal with the subjects pertaining to general provisions like contribution by the central government to the reserve fund, other funds, tax exemptions, appointment and functions of the auditors, rural credit and development, powers of the central bank to make regulations, delegation of powers and liquidation of the bank, etc. Sections 58B to 61 deal with the issues pertaining to penalties which can be imposed by the RBI on other banks and also the penalties which can be imposed by other banks on their customers. We will now look at the schedules. The Act contains two schedules which are to be read as part and parcel of the Act. Schedule 1 contains the information relating to the areas where local boards are to be constituted under Section 9 of the RBI Act. Schedule 2 contains the names of schedule banks in accordance with Section 42 read with Section 2E of the RBI Act. The Schedules 3, 4 and 5 were repealed. The details of various sections repealed are found in the bare Act itself. The further details in depth on the functions and powers of the RBI are discussed in the foregoing lessons. We will now look at the allied legislations relating to banking in India. There are several other legislations related to banking business in India. Briefly, they are narrated here. The Negotiable Instruments Act 1881. Without the application of this legislation, there is no banking business in India. In fact, this act was brought into existence several years prior to the Reserve Bank of India Act 1934 and the Banking Regulation Act 1949. The negotiable instruments like the promissory notes and bills of exchange were in vogue even in ancient India, and they were codified into the law prior to the regulation of banking business under the Banking Regulation Act 1949. The second legislation is the Recovery of Debts Due to Banks and Financial Institutions Act 1993. This legislation facilitates the banks and financial institutions to approach a special forum called Debt Recovery Tribunal for recovery of defaulted loan amounts if the value is rupees 10 lakhs or more. Against the orders of the Debt Recovery Tribunal, a Debt Recovery Appellate Tribunal is also provided to redress the grievances of the banks and the customers. These institutions need not approach the civil court for recovery. The third legislation is the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, SARFAESI Act it is called, 2002. The SARFAESI Act 2002 was enacted by the Government of India to reduce the financial loss to the banks and the financial institutions if the loan is secured and the value of the claim is rupees 1 lakh and above. The preconditions to invoke this act are that the debt is secured, the debt has been classified as a NPA by the banks, the outstanding dues are 1 lakh and above, and more than 20% of the principal loan amount and interest thereon. The security to be enforced is not an agricultural land. The fora for redressal of grievances are the Debt Recovery Tribunal and the Debt Recovery Appellate Tribunal under the Act. The Act provides for a detailed framework for application of the provisions and recovery of debts. The fourth enactment is the Bankers' Books Evidence Act 1891. This enactment, originally intended to apply to British India, the provisions of the English Bankers' Books Evidence Act 1879, under which copies of entries in bankers' books are made receivable in evidence under certain conditions. This enactment is brought into force with effect from 1/10/1891. This act was subject to several amendments, and the major amendments in the recent times were made by the Information Technology Act 2000 and the Negotiable Instruments Amendment and Miscellaneous Provisions Act 2002. This act is relied upon by all the courts and the tribunals. There are several other legislations and regulations connected to the banking business which are listed here, and a detailed explanation is not necessary. The Industrial Finance Corporation of India Act 1948, the Banking Companies Legal Practitioner Clients Accounts Act 1949, the Industrial Disputes Banking and Insurance Companies Act 1949, the State Financial Corporations Act 1951, the State Bank of India Act 1955, the Subsidiary Banks General Regulations 1959, the Deposit Insurance and Credit Guarantee Corporation Act 1961, the Banking Companies Acquisition and Transfer of Undertakings Act 1970, the Reserve Bank of India Board for Financial Supervision Regulations 1994. Wherever it is necessary, these and other acts, regulations are mentioned in the foregoing lessons while explaining the relevant law on banking business.